Introducing Meta Ray-Ban Display, the world's most advanced AI glasses. With a full color display built into the lens of the glasses, it's there when you need it and gone when you don't. Send and receive messages, translate or caption live conversations, collaborate with Meta AI, and more. Be one of the first to try Meta Ray-Ban Display. Visit meta.com/Meta Ray-Ban Display to book a demo and find your pair.
This episode is brought to you by CBS. DMV is a brand new workplace comedy turning misery into magic and chaos into comedy. Starring Harriet Dyer and Tim Meadows, DMV is here to serve you laughs. Watch Mondays at 8:30, 7:30 Central on CBS and streaming on Paramount+.
Atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Northern Kentucky University political scientist Michael Baranowski. I'm joined today once again by my conservative counterpart, Cincinnati area attorney Joey Ashbrook. Hey, Joey.
Hey, Mike.
As usual, I think I could have talked for probably another half an hour about immigration and that and got into nitty gritty, but we ran out of time. And of course, we had a bunch of other things we wanted to talk about as well on that weekend show. We're moving them into the midweek show here. And I thought one thing that I've been following, and I know you've been following it as well, a pretty important Supreme Court case in the last week or so.
Yeah, our first segment for the midweek show is on the case of Louisiana v. Calais, the Voting Rights Act. In an unorthodox Supreme Court case, it's not that common. The court actually heard initial oral argument in the underlying questions, and at the end of its last term ordered a second argument for this year. And then in August, sent out a request, an additional request for briefing on a constitutional issue that the court was not considering previously. And the simplest way to think about it is, big picture, this relates to Louisiana voting. And let me just start with this. This is a really complicated case. We're going to talk about this in simple ways, but just to keep everybody up to speed on what's going on, and then to be able to think through for themselves, and also encourage you to listen to the oral argument, which is really long, but which is kind of interesting. The state of Louisiana has 6 congressional districts. The previous map from a couple maps ago basically was 5 Republican, 1 Democrat district. One of the district was a primarily black district. And there was a challenge to Louisiana's maps saying that they discriminated on the basis of race, and the black voters did not have enough concentration for reflection of their population within the state of Louisiana, and therefore were being denied the effective use of their voice. Their voice was essentially diluted in how the districts were drawn. And the Voting Rights Act is Congress's enforcement statute operationalizing 14th, 15th Amendments to the United States Constitution to prevent racial discrimination in voting, so that coming out of the legacy of the Civil War, that Black people may be able to vote, but you're not going to effectively deny them the power and right to vote by working around it. Things like poll taxes, literacy tests that historically were also used as proxies, are things that in our American experience have been correctly destroyed in those types of aims. So what happened was that the state of Louisiana, in response to a federal district court finding in preliminary injunction that they were likely in violation of the Voting Rights Act, said they have to redraw their maps. So what they did to redraw their maps in the cure and the remedy was create a second district that was largely a black district, highly concentrated. So you had 4, now you have the 6. So if you have the 6 Louisiana districts, now 2 of them are Democrat, 4 of them are Republican. And that's an important thing to keep in mind, because on one level, in hyper-complicated legal arguments, there are other background principles at play, as always happened. And we could be talking about the legal aspects of this. We could also be talking about this within the context of our Texas gerrymandering decisions, because those things all come together. But in the case, what the court subsequently ordered argument and briefing on was they specifically asked whether the state, Louisiana's intentional creation of a second majority-minority district itself violated the 14th or the 15th Amendment. This gets into reverse discrimination dynamics of you're violating if you create a majority-minority district centered around African Americans, are you diluting other people's? Is that essentially making a decision based on race, which we are definitely in the era of operationalizing those dynamics right now and wrestling with how all those things work together. So the oral argument went 2 hours long, and those who like the way the Voting Rights Act currently works said no, there's no problem there. Louisiana needed to redraw its current maps, which is 5-1 Republican, needs to be changed, which would likely turn it into 4-2 Republican, the Democrats picking up a seat. The state of Louisiana, after the Supreme Court ordered change of argument or additional argument and then asked for that second question, interestingly changed its position and said, our map that we redrew is unconstitutional because it requires us to make decisions based on race in redrawing that second district. And then the Trump administration had a more nuanced position that basically would have been less aggressive in setting aside existing or changing existing Supreme Court precedent. It's more complicated than that nuance, but it was actually less aggressive than the state of Louisiana's position and was actually more of a middle road. Mike, did you actually get a chance to listen? Oh, and before I kick you off with a question and get to discussion, one thing that's important to keep in mind as a practical matter of what Section 2 of the Voting Rights Act allows courts to do is one of the great historical questions related to discrimination is, do our federal laws prohibit only intentional discrimination, or does it also prohibit discrimination that has an effect of being discriminatory, even if there's no intention to get there? And that distinction is important because depending on which side of the telescope you're coming from, you want an effects test to exist or not exist, or you want it to be broader. But there's an overall policy dynamic that people talk about related to a practical reason to have an effects test is because without having to have everything come down to a decision of whether or not the other government officials are intentionally discriminating against people based on race. And maybe we'll talk about that. I think that consideration is a little overblown myself, but Mike, did you get a chance to listen to oral argument? I think you did. And as a non-lawyer, I'm curious, what was your take?
Well, I didn't actually get a chance to listen to all of it. Sometimes I do, but I find myself fascinated by them, especially on those occasions when Justice Thomas rouses himself to speak. But no, I didn't for that one. But I got to say, I will say starting off that I'm so glad you did the intro for this one because there are so many moving pieces. I looked at it, it's like, wow, this is a story I'm going to let Joey take the intro for.
It's hard. No, it's really complicated.
A lot going
you can't even
on,
do it justice.
No, I think he did. But so as I see it, the standard interpretation here has always been that when race is the predominant factor in redistricting, it can, but not necessarily is constitutionally okay as long as it survives strict scrutiny. And for folks who don't know what that means that the state has to have some kind of a compelling interest for doing the discriminatory race-based thing it's doing. In this case, would be preventing minority vote dilution. And it also has to be as narrowly tailored as possible to meet that compelling interest. And this view was actually upheld very recently. In 2023, there was a case, Allen versus Milligan. A 5-4 court said essentially that Alabama violated Section 2 in its districting. And I think that my sense from what we saw in this oral argument is that we're going to see a change here. I mean, in Milligan, Justice Kavanaugh was the key vote. And even there, he said, he wrote a separate opinion, or at least that he believed he concurred in part, saying that I'm really concerned about how long race-based redistricting should be around, because to him, and at the time, even in the 60s when this was passed, this was seen as sort of a temporary measure that would not be needed in perpetuity. And that's what Kavanaugh said then. He said it again in oral arguments here, and that's why I expect that this decision is going to go the other way. And even though it was only a couple years ago, my sense is that Justice Kavanaugh has had enough. He's going to end up joining the 4 other justices and saying, you know what, Section 2 of the Voting Rights Act actually is reverse discrimination, and there simply is not a compelling enough state interest at this point to justify it. That's my sense of what's going to happen. I'm curious what you think about that analysis.
Optimism isn't sunshine and rainbows. It's fixing things, changing the way we fix things. It's running the world on smarter energy. Because if optimism never stops, then change can't either. GE Vernova. the energy of change.
This episode is brought to you by Battlefield 6. Battlefield 6 is the ultimate all-out warfare experience. Rip through the skies in aerial dogfights. Demolish your surroundings for a strategic advantage. Harness complete control over every action and movement using the kinesthetic combat system. Drop into multiplayer with your squad, or fight furiously as a member of the Dagger 1-3 squad in a gritty, adrenaline-fueled single-player campaign where you'll defend a world on the edge of collapse.
You know what's really interesting is the Trump administration's position and take, which was that it's not categorically improper to have remedy for especially intentional race-based discrimination in voting. And even if you have an effect, so long as it's actually a real systematic effect, essentially is tied to intentionality. So it's the effect is such that it smokes out that it's really this is intentional discrimination that's going on. So I think what's interesting in the court dynamic from the numbers is Justice Kagan actually asked an interesting follow-up question to the Deputy Solicitor of the United States about their position, saying you're not suggesting a outward bound of what someone could accuse the president's administration's position of being, was clearly debunked. And to be honest, it actually made me think that Justice Kagan understands the logic of the opposite positions, and I don't know how coalition will end up happening. I think that there's going to be a change. I do. I don't know if but the real interesting thing to me is what's the change going to be? And Louisiana's position was different than the administration's position, and I'm really interested to see how the opinion's written and see which of more of those two tacks ends up being taken. But I do think there is definitely an appetite for the acknowledgement that two wrongs don't make a right. And that's just the most blunt way of saying it in constitutional interpretation and enforcement, and that to borrow a line from the Chief Justice, the surest way to stop discriminating on the basis of race is to stop discriminating on the basis of race. I think there's a real appetite for that. And I personally think that's progress. So I think we're going to have some manifestation of that in the voting right. And I'm only acknowledging that. And in the intro, I think that's a good thing. But I also think a lot of this is politics infused. Yeah. And it's not. Yeah. And it's. I think there's a political dynamic where President Trump got a larger portion of the African American vote than has happened in American politics in, I don't know, definitely in my lifetime. And so the extent to which people vote, not necessarily on racial lines, I think it makes a lot of these issues easier because there's broad agreement amongst America. Yeah, in the fringes, you get Looney Tunes. And then there's rhetoric of narrative of the president's a white supremacist, which I think is ridiculous and is not factually accurate. But once voting is less on racial lines, I think a lot of these issues go away because almost universally Americans actually hate justifiably correctly racism. No one should be treated differently or worse because of the color of their skin. And if you're Black, you matter every bit as much as I do being white. Yeah. And I think most Americans in their heart of hearts, animalistically, really do feel that way. And the politics makes everything else more complicated than it needs to be. And I think that honestly is animating a lot of the fights in this area too.
Yeah, I think a big problem is that the politics and the race thing are so closely intertwined because I honestly believe that for the most part, Republicans do not discriminate based on race. They discriminate based on politics, just like Democrats do as well. And so when you have around 90%, say, of Black community voting for Democrats, well, are folks being put into certain districts because of their color or because they vote for Democrats? Well, I would say that I would be willing to bet that if 90% of Black Americans voted for Republicans would be more than happy to put them in all kinds. And so to me, it just gets really, really messy. And then you're getting to intent versus effects. It's just a huge, colossal mess. And I don't have any good answers. I've always been uncomfortable with creation of race-based districts. And I understand the justification, and I think I'm almost kind of with Justice Kavanaugh on this. I think there was a lot of justification for that when there was really clear, obvious systemic racism, especially in the American South in the 60s and 70s and even into the 80s. But it has been 60 years since the Voting Rights Act, and it is reasonable at least to raise that question and say, well, are we going to be districting based on race forever when we do have a 14th Amendment? It makes me profoundly uncomfortable, even though I agree with the sort of anti-racism aims. I agree with anti-racism, full stop, which means regardless of your color. So I'm probably against with a lot of folks on the left, the position they have on this, but that doesn't really surprise me because when it comes to constitutional interpretation, I tend to be much more still kind of a person of the right, I guess, on that, even though when it comes to policy, I'm much more a person of the left.
Yeah. Well, it certainly makes it complicated when, the Texas redistricting and the fight for the House, the Dems pick up an extra seat in Louisiana through the Voting Rights Act. I think that's ultimately the real problem. And the not conflating political fight between Republicans and Democrats and keeping separate the question of, are Black people being treated worse because of the color of their skin, which is abhorrent, and keeping that separate, I think, is healthy to treating people the way that they should be treated. And that what's the reverse discrimination point is largely about stereotypes and the idea that the way that they're going to vote itself is a stereotype and is similar to the soft bigotry of low expectation point, but it's almost like a different type of bigotry of presuming the way people vote. And I think that animates a lot of the rationale of the counter legal argument. And there was an interesting point that the deputy solicitor made, a great argument about there's a whole bunch of white Democrats in West Virginia and nobody's arguing that they should create a district for them. And so the issue becomes, in the president's test, it was that it becomes improper when it becomes a racial discrimination when race subsumes and becomes the thing that matters more than anything else over the state's other race-neutral principles for drawing districts, which is largely partisanship. We don't like, Republicans don't like Democrats getting more districts. Democrats don't like Republicans getting more districts. But political gerrymandering is the number one reason, non-racial reason, since the dawn of time in America that those districts are drawn. And so that's largely the line that the administration was drawing, and honestly actually leaves more relief valve for the world in which if you have some jurisdictions that decided they wanted to go off the rails and go back to where we were not before in our country, that would be easy to still do the same. You could still get the same relief. It wasn't even throwing the regime aside. It was just making it a lot harder. A practical upshot of it, though, would still make it a lot harder to use race as a proxy for political power.
We hope you enjoyed this preview of our supporters-exclusive midweek show. If you'd like to hear the rest of the episode, we hope you'll consider becoming a supporter. Supporters get ad-free access to all of our shows, membership in our Politics Guys Discord group where you can join in on the conversation, and other benefits at different levels of support. To become a supporter, go to patreon.com/politicsguys. You can also support us through Venmo or @politicsguys or through PayPal. You'll find all of our support links in the show notes as well as at politicsguys.com/support. And if you'd like to get the midweek show, but you're not in a position to become a financial supporter, that's not a problem. Just send me an email at mike@politicsguys.com, and I'll be happy to get that set up for you.
This podcast is part of the Democracy Group,